I want to ask you about the conclusion.
Before I move on to this area, I will tell you there was the investigative team was encouraged to think as broadly as possible about violations of the law. And if we had stumbled upon anything that we thought was a viable criminal charge beyond those 5 areas, in any other area, the investigative team would have followed up. And this was not where we started with a limit to the investigation. They dug as thoroughly as they thought was reasonable, and certainly with respect to those financial payments, one of the things that was discussed internally were 3 different theories. Is it a loan? Is it some kind of payment of hush money from the mayor to Breedlove, or is it extortion from Breedlove to the mayor? And all of those are potential interpretations of what you've got. The challenge here is there's no emails, there's no text messages that tell you very much about that transaction. And what we're stuck with are 2 witnesses. Quite honestly, both of them have credibility issues with respect to the entire area that we're discussing. And both of them say it was an honest loan. So there's really nothing a prosecutor has to charge them. I would also say the reason we disclose this stuff is precisely so the media and the public could get the facts and make their own judgment about what they thought.
Right. In the conclusion of the final report, we talk about Breedlove's attempt to gain personally from matters related to his involvement with Adams and his prior criminal record. So that I assume that refers to the Unzipped magazine for which he received an undisclosed payment.
The 3 credibility issues we talked about were the prior inconsistent statements,
right.
The fact that his motive would be challenged in court because he had sought to gain, and the fact that he had a prior felony conviction, which would be used because it was a crime of deception, would be used to cross-examine.
So let's come back to prior inconsistent statements in a minute. But his seeking to gain. So he poses nude for a magazine 4 years after the election, after whatever happened. And certainly his felony conviction, theft by deception, walking out of the department store with clothes under his arms, happens after the crime. So you're disqualifying him in part for 2 choices that he made, which weren't good choices that he made well after the events in question.
What we were doing in the report is that I was explaining to a district attorney who is a trained, experienced prosecutor about why I would not charge a single witness case. And what I was pointing out, and what the report does, is say, here's the things that will be raised in court. And those things, I can tell you, having watched impeachment of witnesses in criminal trials, it is indisputable that those issues would be used very aggressively to show that he's got a prior record of lack of trustworthiness, that the inconsistent statements mean that he's willing to say whatever anyone wants, and that he's attempted to gain, both by trying to get the press to cover him, and then using the coverage that he got to post for a magazine and get paid for it.
Let's focus just on these
points for
a second, because I want to come back to
let me explain. So it's not a question of my disqualifying him. What I'm saying in that report is we have a 1-witness case.
Right.
This is not the case. As I said in the conclusion, a responsible prosecutor would not bring a 1-witness case under these circumstances. And the reason is because the account of the witness is subject to impeachment based on those 3 things.
Yeah, but you would also, as a prosecutor, have the ability to say, okay, you're trying to impeach a guy based on something he did 4 years after the crime. Or the alleged crime. Let's focus on
but what you're impeaching is their current statement in court. Right? When the defense attorney comes in, they're saying, your witness testified today in court X, Y, and Z. Here's why we know this person is not trustworthy. They said the opposite 1 year ago. They committed a crime of deception 2 years ago, and they sought to gain a year ago. All those things are used not to impeach the past statements, but to impeach the present testimony of a witness in court. And that's what would happen here.
Typically go after their motive. Yes, they may have shot with a felony in their past, and yes, they may have both needed for money. But at the end of the day, you've got experience in where you've got to deal with witnesses who could be impeached by the other side because they were going to get some laxity on their jail sentence. What was the motive for Breedlove? How would his motive be impeached by Bob Weaver?
What Bob Weaver would
what did he have to gain by lying?
What Bob Weaver would do in this case, if this case were charged, and again, I just want to say that I would be subject to discipline by the bar had I charged this case. If we charged this case, Bob Weaver would have done exactly what I lay out in the note. I mean, the reason, when Bob sent us that letter that lays out his view of the case, I never read that letter. Our investigative team did. I never did. I didn't need to see what Bob would say about the case. The reason that that letter tracks my analysis is because any experienced criminal lawyer would look at this case the same way, which is, these are the things that the defense is going to use. You have a one-witness case. Is it a witness who's going to hold up in court, or are the things that will be used to impeach the witness? And the three things that would be used to impeach the witness are those three things, and that's why they're in the report.
Okay, so
And any experienced prosecutor will look at these facts. Any experienced prosecutor will tell you those are things that the defense is going to use very aggressively to discredit the witness in the eyes of the jury.
So the other 2 points that you've actually made four, or let's separate them into four. You've addressed the unzip, you've addressed the fact that the shoplifting took place well after the alleged crime, the crime that you were trying to determine whether it existed. So you made the point of talking about how he aggressively shot this story to the media.
Yes, which I don't think that alone is that important, except insofar as it's, again, another example of inconsistent statements, where on the one hand, Mr. Breedlove had said that he was not shopping this story to the press, and on the other hand, he was. And again, the reason that's significant is the defense would use that in a case to discredit his testimony.
Well, the story that he was shopping, and by the way, the report is inaccurate about some portions of that, because he never shot the story else. But in any case, the story that he was shopping to the murderer is true. He was telling Amy Ruiz, we had sex. That's true.
Yes, and the point I'm trying to make is that he was, for instance, telling Unzipped magazine that this was being leaked by other people to get back at him, and meanwhile he was the one that was doing it. Again, the reason that's not four things, the reason I have had three things is because for me there's three that are important. He's had inconsistent statements, he's got a conviction for deception, and he had a potential motive, which was self-profit.
So the text messages that you have turned over appear to corroborate his version of his interview with Sam Kaufman, in which he says, I told Kaufman, time out, I called Adams, I said to Adams, should I tell him about the kisses? Adams said no. My reading of the text messages corroborates his, at least part of that version. So he talked, I think the Oregonian, I think the term he used was that Weaver and Kaufman poisoned the well. But there appear in the interview statements with Breedlove a lot of reasons to believe that Adams told him, don't tell Kaufman about this.
Again, if we had proof beyond a reasonable doubt that there was obstruction of justice, meaning one witness had told another witness to lie and we could prove it beyond a reasonable doubt, that would be a chargeable offense. And the facts of the matter here are very difficult when your one witness has made very contradictory statements about the basic facts in the case. And that's really, I mean, we can parse this a million ways, but the bottom line, I mean, I will tell you as well that part of the challenge as a prosecutor is when you go into court, you are telling a jury to rely on someone. And though you don't vouch for them personally in the trial, the whole trial is about the state saying, we believe that person over there is guilty beyond a reasonable doubt of a crime, and the way we're going to prove it is we have this person whom we believe. And a prosecutor should not be putting witnesses on the stand unless they believe the witnesses are telling the truth. And here, our investigative team, at the end of the day, was unsure whether Mr. Breedlove was telling the truth or not. And that goes to the heart of the problem in the case.